tonight. We understand that you have many other commitments and prospects for this evening, but we appreciate you joining us nonetheless. My name is Kayla Murray. I'm the Standing Committee Chair for Finance, Economic Opportunities and Tourism in the Western Cape. And I'm joined as well by a member in the House as well as the members online. So I'll just afford the member to introduce himself in the House, and then from there we'll move to the members online to introduce themselves.
Good afternoon, Chair, and good afternoon, everyone. My name is Mbulelo Isaac Sileku. I am a member of the committee. Thank you very much.
Thank you very much, member. Members online, if you'd like to introduce yourself.
Thank you very much, Chair. Member Brankesh here, member of the committee. Thank you.
Good afternoon, Chair. Andrikus van der Westhuizen, also a member of the Standing Committee.
Good afternoon, Chairperson. My name is No Kondlo, member of the.
I see member Nkondlo online, but I can't hear anything. But we do note your presence, member. All right. With that, I also just wanted to acknowledge again each and every single person that's joined us today, whether representing an organization within procurement or an interested member of the public, as well as those who are watching online. Thank you again for joining us. We're also joined by National Treasury, so I'm going to afford them an opportunity to introduce themselves as well.
Thank you, Honorable Chair, and the honorable members of the committee. My name is Willie Matebula, and I'm from the Treasury in Pretoria. Thank you so much.
Good afternoon or evening, Honourable Chair, honourable members and members of the committee. My name is Leander Peterson, also from National Treasury, with Mr. Matebula. Thanks.
Thank you very much. For the record, we haven't received any apologies for today's meeting. Before we proceed, though, I would just like to run through some house rules. For those guests who've joined us online, if you could kindly keep yourselves muted and keep your video off unless called upon to speak. For the duration of today's meeting, we'll essentially be receiving a presentation from Treasury. Thereafter, there will be an opportunity for any questions of clarity that you might have. Following that, we'll have our submissions. We have received requests for oral submissions prior to this, so we'll give those who've already made those requests precedence, and they'll be able to make their submission first. Thereafter, if anyone else would like to make an oral submission, they can do so. With that, I would now like to hand over to Treasury, but sorry, just before I do that, I'd like to note that should you require any translation services, there is a translation device in front of you, and you can just scroll through the channels until you find the language that you'd like to listen in. Okay, all right, over to Treasury. Just a reminder for speakers to use the mic.
That's fine. Oh, I'm going to use yours. Okay, great. Thank you, Chair. That's my switch mine off. Thank you very much. Let me just quickly go back. Thank you, Chair. Chair?
Yeah,
but where is my presentation now? So I've lost my presentation. My presentation. Sorry, Chair. I'm just gonna go straight to my presentation. Apologies for that.
Is my audio working now?
In Bankontlo, we did hear you briefly, but it did sound very distant.
Okay. This Smith is low. Huh?
Okay, Chair, thanks.
I don't know what's happening here, but okay. There you are. Yeah. Oh, just share it. Share. Thank you. Thank you, Chair, and thank you to the members, and apologies for that slight glitch. As indicated, my name is Willie Matebula. I'm going to go straight, go to the chase, and then present the public procurement bill. And just also to indicate, Chair, that the bill was introduced last year in June to the National Assembly by the Minister of Finance, and it is a Section 76 bill. Hence, it is before the committee here, which is, of course, and what we want to do today, at least to present the aims of the bill broadly and the key principles that are contained in the bill. And having said so, Honorable Chair, it is important to indicate that as part of procurement, public procurement, as part of that process, the other objectives, of course, is the leveraging of public procurement to support the broad socio-economic objectives of government, and that is contained in the Constitution. Then just also, Chair, just by way of a background, just to indicate that one of the objectives of why this bill had to be put together is the fact that there's a myriad of a piece of legislation that regulate public procurement in the country, and as a result, there's a lot of confusion in terms of which piece of legislation applies where and so on. So this particular piece of legislation seeks to be that national regulatory framework, a single framework in the country that will regulate public procurement at all spheres of government. We also want to indicate that some of the laws that relate to procurement predate even 1994. So that's the reason we've never had a piece of legislation in the country that consolidate all issues that relate to procurement into a single framework. So that's what now that's what this bill, aims to do. Then, Chair, the bill has got 7 chapters, and I'm going to go through them. It's got 7 chapters all in all. So I'm going to go through each one of these chapters. Chapter 1, of course, has got definitions, the objects, and the applicability or application and administration of the Act. The definitions, I'm not even going to go through them, but they are outlined in Chapter 1 in detail. So, and the reason why you want to also make sure that you define the certain definitions in the bill to make sure that when you apply the bill, you can always relate it back to what exactly it means and so on, and give it the ordinary meaning, some of those definitions that we have. And I must also indicate, Chair, that the bill is premised on 3 sections of the Constitution. So 195, 216, and 217, among others, of the Constitution. So it's premised, around those issues. And then the objects of the bill, of course, if you look at Section 216, it refers to the introduction of uniform norms, treasury norms and standards. That's what 216 says. And then 217(2) refers to the preferential, procurement framework for all procuring institutions within which to implement their procurement policies as envisaged in that subsection of 217. Now, of course, there is a clause 2 which sets out the minimum requirements for uniform norms and standards, such as ensuring efficient, effective, and economic use of public resources, and of course, advancing ethical conduct in the way procurement and combating corruption, stimulating economic development, and of course, advancing transformation, among others. Now, as indicated earlier on, the bill will apply across all spheres. So you're talking at national as well as provincial departments, constitutional institutions, as well as municipalities and municipal entities, and of course the some of the public entities which are listed in Schedule 2 to 3 to the PFMA. And one other provision that we have, Chair, in this bill is that at least Chapter 4 of this bill should be applicable to provincial legislatures as well as National Assembly, just that Chapter 4. Because, I mean, the other chapters, of course, may not apply since these two institutions, provincial legislatures as well as the National Parliament, have got their own piece of legislation. So they're quite independent. But that Chapter 4, we've made a provision that should apply. Now, that's what, in a nutshell, Chapter 1 is all about, and the details are contained in there. Now, Chapter 2, Chair, relates to the establishment of a public procurement office, within the National Treasury. And it also outlines the functions of that office. But having said so, provincial treasuries have got also a role which is similar to what the public office will be doing. So are procuring institutions. These are all government institutions. And I must just clarify one thing, Chair, which we picked up during the public, hearings and public participation by communities around the country, because there is, of course, the impression that procurement would be centralized within Treasury, and that's not the case, by virtue of the fact that you've got the Public Procurement Office at Treasury. That office, the role of that office, including the roles, of course, of the provincial treasuries, is to set the framework. That's all we do. If you look at the architecture of the public procurement in the country, it is center-led, and I think it's still as center-led. So meaning policy development is centralized, but execution is decentralized. We just want to make that distinction. It's a center-led kind of system. So we set the rules of the game. This is how the game, you should be played, and therefore execution by various institutions, they will still have those powers to do what they need to do. But the framework at the central point, of course, that's what we'll do. And as indicated, treasuries will also have roles similar almost to what the Public Procurement Office has to do. Then further in Chapter 3, Chair, it talks to the procurement integrity. Here we've tried to also incorporate some of the issues raised during the Zondo Commission of Inquiry, because there's certain recommendations that Judge Zondo made. So Chapter 3 also talks to that procurement integrity. And of course, this relates to the conduct of the officials in government, and it also relates to the conduct of suppliers, those that are doing business with the state, including, of course, the tribunal, which we'll go to later on in one of the chapters, and any other person, of course, that is involved in a procurement process. There is a particular expectation of how they should conduct themselves, including us as officials. Now, in here, Chair, the bill also, prohibits the undue influence, and interference in procurement processes by people who might think that now here's an opportunity. They instruct certain people, officials, to undertake certain acts which are inconsistent with this act. So it makes provision. And also there is a provision for automatic exclusion of specified persons from submitting tenders and bids in government. And that, of course, includes the public office bearers and employees of the state, etc., etc. I mean, that clause 13 of the bill deals with those people. And clause 14, very important, because clause 14, of course, stipulates what a person involved in procurement can do if that person is given directions which are inconsistent with the Act. So in other words, if anybody were to come and instruct an official to do something which is incorrect or wrong, if I may put that way, at least Chapter 14 provides the rules of what that person should do. In fact, to be honest, it simply says if you refuse, if I were to summarize, to take instructions from anybody else. Then also key to this chapter is the provision for debarment. This, of course, relates to bidders and suppliers who may be involved in defrauding the state, and that there should be actions that are taken. At least now, this one provides a clarity, which is missing in the current legislative framework, except that as Treasury, we issue instructions to say there's a gap in law, and therefore you augment the gap through instructions to say this is what you do to restrict any person that is found to have wronged the state or defraud that state. But at least now it is in the Act itself. So the debarment of people that are mischievous. That's what we'll deal with. Then, Chair, that's what Chapter 4 in a nutshell, I'm sure Chapter 3 in a nutshell provides. Then Chapter 4 is a chapter that I may say is a direct function, is a function of the Constitution. The subsection 2 and 3 of Section 217, because it talks about preferences in the allocation of contracts and also about the protection of persons or categories of persons, you know, who were historically disadvantaged by unfair discrimination. So that's what Chapter 4 is trying to respond to. Now, in our interaction during the SCOF process, Chair and honorable members, the stakeholders raised very important issues around the fact that perhaps that particular chapter in its form in the bill that was presented on 30 June last year may not necessarily be detailed enough to understand what should be in that chapter. So then Chapter 4 here has passed as part of what was passed by the National Assembly on 5 December, details some of the issues that we've included in here. Firstly, there's clause 16, and this clause makes it clear that the framework set out in the chapter is giving effect to the Section 217(2) and 3 of the Constitution. It also makes it mandatory for procuring institutions to implement preferential procurement in a manner envisaged in this framework. Now, there are certain of course, elements of this chapter that we included in here. There's a chapter around set-asides. And let me also indicate that the issues around set-asides and many other provisions, of course, in this chapter come a long way. They come all the way from NETLEC processes, because this bill was subjected to NETLEC. So these are new things. These are not new things, but they have always been there in the bill. I mean, from NETLEC to the state law advisors, to FOSAT meetings, and also to the cabinet committee, not once, but many times, and eventually passed by cabinet for introduction to Parliament in June. And I think the cabinet passed it in May last year, the 10th of May to be precise. Now, we've provided for set-asides. The set-asides have got a number of categories of persons to whom set-asides would apply. And what we're also saying here, Chair, is that there will be a threshold. So this is not an open-ended kind of provision. There will be a threshold set to say if you're setting aside it should be within this threshold and not above that threshold. I think it's important that we mention that. And we're not providing this threshold in here. And the reason why we're not providing threshold, we're saying at least the thresholds must be provided for in the regulations, because we've learned that if you put thresholds in a primary legislation, it becomes very difficult. Right now, we're dealing with the Preferential Procurement Policy Framework Act, where we've got the 80-20 and the 90-10. And since 2000, we can't deal with this because it was included in the primary legislation. So that's a danger of including thresholds in a primary legislation, but at least the enabling provision is made in here, and then that would be discussed in the regulations. And I will talk to the regulations later on, Chair. Now, one other part, of course, one other provision here is a pre-qualification criteria for preferential procurement, which is provided for in clause 18. And we're saying the pre-qualification criteria will have a higher threshold than that of the set-asides. But also, equally, in here, we didn't put in a threshold. It would be prescribed. And prescribed, of course, means that there would be regulations that will prescribe that particular threshold. And by the way, Chair, I must indicate that the regulations themselves would be subjected to a similar process of the bill. When regulations are drafted, they will go into the public, public domain, and then the public would have an opportunity to comment and provide views and so on in that. And then that's one, but also not only the public, but we've also made a provision that regulations must also come to Parliament. So it will follow almost a similar process. And then I think this would be a very transparent process that would be followed in this instance. Now, there is also a provision here to try and encourage at least the private sector to also, contribute towards transformation. It's a critical issue, Chair, that we must to also contribute by recognizing the BBBE levels of contribution. Now, another provision here, Chair, the third one in Chapter 4 is subcontracting as a condition. But what we're saying here, and the categories of persons as well, and are also outlined in the bill of who the subcontracting will apply to. And what we're saying here, the subcontracting should not be something also that everybody does, even if it's not feasible to do so. So we've got that caveat to say it must be feasible to do so. If it's not feasible, it's not feasible to subcontract. But at least we're making provision for subcontracting. And I must also stress on this fact, Chairperson, and say why we're saying there must be subcontracting, especially for small businesses. Because if you look, I'm just going to take, and I'm sure my colleagues here, if you look at one of the pieces of legislation, you take the CIDB, the Construction Industry Development Board, the Act. So there, the grading system in that particular act, you will pick up that from grade 1, maybe up to grade 6. You come to a particular threshold. So in other words, these small businesses can also undertake projects up to a certain figure, but up to a certain level, then they can't participate. So it only certain grades that are eligible to participate on big projects. Hence, we're saying at least the small businesses must also be afforded an opportunity to participate in projects that are undertaken by big, but where feasible to do so. Now, we also made a provision here, Chair, to say at least the people, the persons or categories of persons identified for empowerment must be citizens, or companies must be owned by citizens of the country, South Africa, because I mean, it's a moral obligation to do so, to say, let's prioritize our own companies in the country to build our own economy. So that's provided in there. Then the other issue, Chair, which is also quite critical, and stakeholders have been raising it, not only stakeholders, but at cabinet level as well, is around this issue of designating of certain sectors, subsectors, industries, and products for local production. So this is provided for now in this chapter. And by the way, this is a power, of course, that we are conferring to the minister responsible for trade and industry. He is the one that should chart the way forward and say, identify specific sectors that must be designated for local production to build South Africa's industrial base. Now, and in here, we also say that bids that do not make that particular designated sector would, of course, be disqualified. Now, there are certain conditions that we've made because we also don't want to have an open-ended kind of a designation regime. So we've put some kind of caveats to say, Minister, if you identifying in the country specific sectors for localization, at least there should be a minimum of specific players in the country. Then you then designate, because otherwise, if everybody were to come as individual and say, please designate my particular product or my company for localization, you might unintendedly promote monopoly, which is what we're trying to, or even oligopoly for that matter, which is what we're trying to avoid. Now, unlike the current designation regime, where the public does not necessarily know what has been designated for local, here we've also made a provision that the minister responsible for trade and industry would have to gazette what is provided for, what should be designated locally to provide those opportunities. And of course, the Minister of Finance will also have an input and comments in this particular area. It's not going to be Minister of Trade and Industry alone, but also Minister of Finance will participate in that. Then we also made provision for other preference measures because we are mindful of the fact that we may not have covered everything, or certain procuring institutions or may want to promote certain measures in terms of preferences, and they should be allowed to do so in terms of this framework. Of course, there were also measures to advance sustainable development and also measures for beneficiation and innovation. And I must stress this issue of beneficiation. I think as a country, I don't know how the balance of payment looks like, but as a country, you may realize that since we started this process of designating, we import a lot more than making in the country. So in other words, we are exporting jobs when we should be providing jobs in the country through beneficiation. Our raw material is exported as raw and then imported as finished product. There are a number of them. I can just take iron ore as an example and say iron ore and many other raw materials, including clothing and so on. I mean, these things are, you're talking about leather is exported, and then we import all these things as finished products. So we are saying here in this bill, there should be local beneficiation and innovation, of course. In our current procurement regime, unique, innovative ideas, you always have to follow a certain process. For instance, where we're saying, we call it unsolicited bids. And for you to even come up with an innovative system, you need to comply to certain issues around, no, we don't accept ordinarily unsolicited bids until unless you motivate. But at least now we're providing some innovative ideas in the procurement system, because quite a big space. Some of the stakeholders were even saying, no, you must stress. They submitted almost comments in excess of 300 just on innovation. But at least we are, recognizing innovation for advancement and creation of jobs, intensification of labor absorption, and importantly, Chair, we are also talking about development of small enterprises within geographical areas. So, which is what we call locality. Yeah, people may want to say, I used to, have discussions even at Netlek some time ago, a small little town somewhere on the West Coast. And people are saying, but people are out of jobs in that area. And yet there are other people that are coming to get jobs in those areas. At least now we are saying, look at the geographic area and promote small businesses and so on. So that's provided for here as well. Okay. And then we're also talking about contracting conditions. And all these details that I'm talking about here, Chair, will be expanded upon in regulations. And I've already said that the public will have an opportunity to participate in the drafting of regulations. Now, and unlike the current framework in the form of the PPPFA, I think, Chair, it's now history what the Constitutional Court said on the 2017 regulations around the consistency of those regulations with the Act. Now, in here, at least we are providing a wide menu of preferences other than just the 80-20 that we had in terms of price in the current system. And I must also point out that during the interaction with stakeholders, stakeholders were saying to us, no, price is actually discredited around the world as an evaluation criteria. So that's why we're providing for all these things so that people consider value for money as well. And I must also indicate that value for money and transformation are not mutually exclusive. So all these things can be achieved simultaneously. Now, that's what Chapter 4 is all about. Then Chapter 5 is around general procurement requirements. And this is now the chapter that will deal with technical issues. So if you've got a procurement practitioner, this is a chapter where regulations will outline on what process do you follow. And in here, Chair, we're saying the minister must prescribe by regulation that particular framework now within which procuring institutions must implement their procurement systems. Now, we're also saying here a strategic approach to procurement. We've just taken a strategic approach because, I mean, some stakeholders are saying, hey, but to procure infrastructure is not the same as procuring pens and pencils. And we agree. We agree with the stakeholders that that's correct. Because, I mean, if you procure infrastructure, it's not the same as pens and pencils. But if I were a member of the education sector, and I'm sitting there and I'm saying I've got schools in this province and I've got so many schools and there are textbooks that must be procured, the stationery that must be procured, very complex. So the learner teacher support material, you also can't just buy it anyhow. You still need to apply strategic approach in the procurement thereof. So that's what we say. And that would, of course, be an extended kind of application of strategic approach to procurement, more than just infrastructure and capital assets. Now, also here, there are types of procurement methods that will be prescribed. Currently, we say to procure, which is fine because we're following 2171. Yeah, but there are other procurements that need to be procured differently. Where you have a crisis right now, we've got a crisis in the country, we're talking electricity and so on. And there are certain kind of procurement methods that we must follow. And those methods will also be prescribed in here. And it also, of course, provides for measures. That's chapter 5. I mean, we talk about this, whether you're talking the procurement of sector by sector, energy, rail, road construction itself, bulk water infrastructure, ICT infrastructure, all these types of procurement would be prescribed in here through regulations, because we couldn't just put them in here in the primary legislation, because we wanted to allow a number of them prescribed through regulations, so that as the system evolves, at least we're able to add a number of other procurement methods, and of course based on international best practices, where we could also tap and see what other countries and jurisdictions are doing insofar as procurement is concerned. Now, the other issue here, Chair, in chapter 5, are issues around the measures to prevent the abuse of procurement system, investigation of allegations of corruption, and of course, rejection of certain recommendation of award and cancellation of contracts in specified circumstances. And then also what we're providing here, at least measures for access to procurement processes. I think I was in Tata on Friday last week. Now the people in Tata say to me, but what happened to that, procurement process that used to be there, where people would come in and then they submit their tenders and they sit there, and then these tenders are opened. So by the time you leave that room, you know whether you've made it or you didn't make it. They say, why don't you bring that back? But I mean, that's a comment that we also, now what we're saying here, at least the public would have an opportunity to access procurement processes. We've made that provision in here. All right. Thank you, Chair. I can continue. Okay. Now, the one other issue is around the disclosure of procurement information, and a particular format in which that information must be provided. Now, we're very, mindful of the fact that currently we've got different systems in the country where we can't extract information into a central portal. But here, because we're providing for the use of technology, so that we can extract procurement information data and so on, because that's very important in policy development, but not only public policy development, but also in terms of monitoring and evaluation of the performance of the state. We're also providing here the protection of confidential information, including personal information in terms of POPIA and so on. So that's provided for here. But also in this chapter, Chair, we've made provision for the use of another organ of state to deliver services. So the number of state institutions that are created for specific purposes, which, people have always been saying, but we've created these state institutions as a state, why can't we go directly to them and so on? So here, at least we've made provision. Of course, there would be conditions. Now, chapter 6, I'm almost done, Chair. Chapter 6 is a chapter where we're providing for a dispute resolution. I may call it alternative dispute resolution. I'm sure the legal minds in this room would understand what that is all about. Now, why we're providing for a tribunal? Now, why are we providing for a tribunal? We're providing for, because firstly, if government is litigated, it takes time for courts to make decisions. And by that time, when courts are not making decisions, service is suffering. So we want to make sure that we expedite dispute resolution where people are aggrieved by decisions taken by procuring institutions, expedite that process, to also to make sure that the service delivered does not suffer in the process. And 3, which is quite critical, is the fact that it's very costly for the state, for government. If you look at our litigation cost as a state, it's very big, quite huge. And not only the state, but your small businesses who may not necessarily have deep pockets to litigate against the state. So we also want to make sure that small businesses and other companies who do not necessarily have funds at least have got a recourse through the tribunal. And then what we're saying here, if a bidder is dissatisfied with a decision of a procuring institution, so this particular chapter says go to that procuring institution, and if you're not happy, then you take your matter to the tribunal. Okay, thank you very much. So you take your matter to the tribunal, and the tribunal has got certain number of days within which they need to make a decision. But if you're not happy with the decision of the tribunal, nothing prohibits an aggrieved bidder to approach formal courts for recourse. So you still have got that option, but at least we are providing a mechanism within which disputes could be resolved. Now, what we're saying here, Chair, is that we are compelling aggrieved bidders to exhaust this process before going to court without, stopping them from going to court. That's what we say. Now, the tribunal, we do indicate that the tribunal would be appointed, the members thereof, and there are certain requirements for the members that must serve in there, and it would also be chaired by a retired judge. Now, let me just quickly explain here, Chair, because I think during our interaction with stakeholders, there was a concern that, but the tribunal will be sitting in Pretoria. What happens in Cape Town? What happens in Kimberley? What happens in Uppington or in Alexander Bay or even Musina for that matter? Now, how the tribunal will work? The tribunal will work through panels. So if there's a matter here in Cape Town, and a matter is lodged with the tribunal, so there will be a panel, which of course will operate under the auspices of the tribunal to deal with the disputes in particular areas, in various areas. So that's how it's going to operate. I think we're also making that provision in the bill. That's what chapter 6 is all about, Chair. Just in a nutshell, as indicated, if people are still not happy with the decisions of the tribunal, then they can go to court. And what we're also saying here is that whilst the dispute is under consideration by tribunal, that particular procuring institution cannot proceed and award a bid. They must wait. So there's a standstill period. They must wait until there's a decision that is, going to be issued by the tribunal. And we're also saying even debarment measures, because if the tribunal would have powers to also review debarment, where people are debarred from doing business with the state. So that's what chapter 6 is all about. Details are called. Then the last chapter, Chair, chapter 7. These are general provisions. Now, here, the Public Procurement Office is of course, given powers to investigate procurement-related matters to establish compliance or non-compliance. This is not a criminal investigation as we know in terms of law enforcement agencies. This is purely to say, are you compliant or are you not complying with the rules of the game? That's what the PPO, the powers. And also the bill provides for the criminalization, among others, of conduct of persons who knowingly give false information, misleading information or evidence, or even interferes with or exerts undue influence on any official of a procuring institution, or a member of a tribunal and so on. That's what this, and it also makes provision for, to deal with issues where there is collusion, where people are conniving to commit corrupt, fraudulent, and so on, collusive acts. And of course, in cases where there is loss of public assets or funds as a result of negligence. But also, Chair, we're saying at least in here, there's a provision for limitation of liability for powers and duties performed in good faith, right? In terms of the Act. And also, we're making provision for exemptions. Now, if you look at the current piece of legislation, you can check Section 92 of the PFMA, or you check Section 170 of the MFMA. It makes provision for exemption where people can come and say, hey, I'm applying to the minister to be exempted from this particular act. So the current process is much more open-ended. So you can come up with any reason for not complying to be exempted. But in this bill, we've provided grounds. And the grounds, I must say, Chairperson, are quite limited. So we've provided grounds for exemption. So anybody that wants to be exempted from this piece of legislation would have to satisfy those grounds. That's the first part. Then there's another part that talks to departures. Yeah, I referred to 170. Actually, 170 is the departures in MFMA and 79 in PFMA. So where is a provision that the National Treasury on good grounds can grant a departure from an instruction or regulation or any other, instruction issued in terms of this act. And then it says the Treasury must then notify the Auditor General when it does so. So it's a very open-ended. But in here, for departing, because departing and exemption are two separate concepts. So if you depart, it's just departing for a specific reason, but exemption is also for something else, because when you exempt, you must gazette. Now in here, we also put grounds. There are grounds to say on what are the grounds that would justify a departure from this act, including in regulations or instructions. That's what is provided in for. And of course, I indicated that this particular chapter also empowers the minister to issue regulations, of course, regarding all matters specified elsewhere in the bill, such as preferential procurement chapter 4, a procurement system in chapter 5, the procurement methods that we spoke about, including PPPs, transversal term contracts, and the use of another organ of state for goods and services. And that list, of course, of other matters which are provided for in clause 64. Now, what we're saying here is that in drafting the regulations, the Minister of Finance must consult with other ministers whose portfolios may be affected by the regulations. And of course, we did indicate that the regulations will be, done through public consultation as well. And then also what we've provided here, the regulations must also be subjected to parliamentary scrutiny. So they also have to come to Parliament. Now, I've said that there would be regulations for different things and so on and what have you, and I'm not going to go in there in that detail, but it's contained. Now, lastly, Chair, as I close, in the bill itself, you will see there's a schedule at the end, and that schedule contains about 16 pieces of legislation. And those pieces of legislation would either be amended to be in line with this bill, and some of the pieces of legislation would be repealed. For instance, the provisions of the MFMA that deals with procurement, provisions of the PFMA, treasury regulations, and many other pieces of legislation where there are issues that relate to procurement. I think it's a few pages, Chair, before you come to that one, but you'll see there's a schedule in there. Yeah, and there are almost about 16 of them. So some of them will be amended, some of them will be repealed. So the PPPFA in its current form, as we know it, will be repealed. The State Tender Board is a piece of legislation that is dormant, but it still exists in the statute books. So that as well is a 1968 piece of legislation, which was prior to the Constitution, is also one of the pieces of legislation that we will repeal. The CETA Act, we're making amendments there. CIDP, we're going to make amendments in there and in many other legislation just to make sure that there's alignment with this bill. Now the coming into operation of the Act would be determined, by the president, and the president is given powers to decide, what are the dates, which part of the bill should apply, when, and so on, because there are different categories of procuring institutions. So that's our story, Chair, and thank you very much to you, Honorable Chair, honorable members of the committee, and the members of the public at large. Thank you very much. I'm handing back to you. Thank you, Chair.
Thank you very much, Mr. Matabule. We really appreciate it. So we'll now move on to any questions of clarity, and welcome to those who've joined us now. It's great to see the House a bit more full. So if you have any questions regarding the bill, you can just raise your hand, whether online or in the House. Just a reminder, after we deal with questions, we'll move on to submissions. So if there's anything that you're unsure of at the moment, this is your opportunity just to get that clarity. Right, are there any questions? I see the gentleman at the back there. Just a reminder, when you ask your question, if you can say your name, who you represent, where you're from, and then put on your mic in front of you.
Thank you, Chair. Am I audible? Yes, I am. Thank you, Chair, and thank you, sir. I am Rudzani Kennedy Ramatse from Stellenbosch. I come with the civilians of South Africa, representing civil society. And I have a question in terms of the what was presented before us this moment. I'm not sure if this might be precisely for Chapter 4, but is there a stipulation where we might be able to know in terms of percentage what has been stipulated for local partnerships for big projects or so? And it's not in particular to a specific industry, because I do believe that it is so essential for us to look at local partnership for any project happening in an area, which is something that it's not missed and was mentioned, and I'm glad that it was mentioned, but percentage-wise or so would be really good for us to now say, okay, how do we go then about this percentage? Well, how does the distribution look like? Because we cannot always allow other people to come and build for us without us. And that is one of the biggest problems that we have. That was the first one. And the second one, yes, it was spoken about also, I believe, in still Chapter 4, about specialists, acquisition or procurement specialists. I'm not sure, I'm not very familiar with how municipalities work or so at district level or municipal level, but is there any availability for the public to access this specialist? Because we cannot talk about equality or equity in this manner where we are saying that anyone can apply for a tender, can bid for this and this without having a dissemination of information. I believe that information is something that is critical and something that should be seen as something that basic South Africans should have, especially when they want to participate in doing business with the state. So is there a specialist that can be given to the public or so, or that the public can have access to, so that they understand the requirements and understand how to go about the certain processes or so that not a lot of people are missed in the process? And for now, I believe that is all. Thank you.
Thank you very much. We'll hand this question straight over.
Yeah, I'm sure my colleague here would also assist. Look, as indicated earlier on, Chair, and this is a primary legislation. So we refrained from putting percentages in here, but we will deal with those issues in the subordinate legislation, which is the regulations. Reason being, once you put something in a primary legislation, to change that law, it takes very long. currently we're talking about the 80-20 and the 90-20 preference point systems. And these systems are contained in a very short piece of legislation, by the way, a 6-section act, the PPPFA. And this act was passed in 2000. We are now in 2024. The act still exists, and the 80-20 and the 90-10, those percentages are in that act. We can't do anything about it until that act is repealed or amended. Now, the problem is, once you lock yourself on percentages and so on in this primary legislation, you are stuck with those percentages. So we're allowing the system to say, issue regulations, and in regulations, we can then set percentages, et cetera, et cetera. But of course, the public would also have an opportunity to comment on those things. At least regulations are easy to change. I'm not saying you can change them willy-nilly, but they are easy to change rather than primary legislation. So that's the reason why we're saying maybe percentages we should look away. And then your second question around procurement specialists, I'm not so sure talking about the people that are actually executing the procurement. Or I didn't get that question very clear.
Yes.
Chair. Thank you.
So it's about the availability of those kind of specialists, especially for people who will be bidding. It's really important for people to understand what is the bidding process is a bit complicated, if I can say. Even people who have been bidding for years, once or a while they get a hiccup there and there. And to make sure that the public has fair knowledge and there can be fair trade, if I might speak on that, has fair knowledge on what is happening in their community or around them. Is there someone there to disseminate information in the right manner so that they also they can be able to, you get that.
I hear you. No, it's true, Chair. Look, we, as officials, we are expected to educate the public, to avail ourselves and explain some of these very technical issues that we talk about. And I understand it. A very technical procurement, if you are not in the environment, the space, becomes quite complex. Hence, a number of people will say to you, but I submitted a tender, and I don't know why was my tender not of course, acceptable. So I think we have that role, save for the fact that we may be thin ourselves in government, because you've got all spheres of government, including and so. But I think where our services are needed, we'll definitely make sure that we avail ourselves. It might not be me, but if you are in the Western Cape, because I come from Pretoria, I might simply say my colleagues here at the Provincial Treasury here in Cape Town should be the ones that at least look around the people in here, including, of course, municipalities. You can talk about Cape Town as a metro and all other surrounding areas, but we are there for the public to disseminate information. Thank you, Chair.
Thank you very much. Are there any further questions? Do we have any questions online? Okay, I see no questions. So we'll move on then to oral submissions, and we'll go ahead by order of those who've already requested to make submissions. The first submission that I have is from Sean Scott and Henry Carlser from Worldwide Integrated Logistics. Just to confirm if you have access to share the screen.
Thank you, Chair. Thank you very much. Thank you for the opportunity, and thank you for the clarity from National Treasury. This is a submission that has been put together by 3 people, but it's going to be important that we share some context. One is Advocate Helen Fenter. She's based here in the Western Cape, very widely respected, well respected within the public procurement community. Professor Theo Kino, who is also here today, has participated in this process, and myself and my colleague Henry Carlser. But how we've put this together has been through a a process of consulting with a number of practitioners in South Africa, including here in the Western Cape. And we've had a number of different webinars, 3 in particular that are focused on this. There have been 120 participants on that process, and we've put together a document which we will make available to this committee, which has been circulated, and you might even see some aspects of this elsewhere. So this is not just 3 people, it's been the collaborative effort of many. National Treasury started off saying that one of the objects of this is to avoid fragmentation, and clearly stated that provincial legislatures and Parliament just has to comply with one aspect of this, which is Chapter 4, and has left out of this that the rest of the bill. And we're saying that's going to lead to continued fragmentation. It's going to be for this Parliament and the other parliaments in the country to put their hands up and say this is going to have a long-term detrimental impact on the provincial legislatures. My colleague Henry does a lot of training in this space and has trained provincial legislators, this provincial legislature, on bid committees. But now, if you're not part of the legislation, eventually you're going to fall behind, and the rest of the capacity development process that we have in the country, the system support, this provincial treasury will not have access to that. And you'll start to find that will have longer term implications. There is a section 33A in the bill that says that donor funding is also subject to this bill. And we think, and many think, that could have a risk on donor funding. Many donors donate the money with certain conditions, and those conditions very often are reasonable. Like, you need to buy the equipment directly from the OEM, for example, just so that we have the integrity of the warranties, etc. But that's not going to be allowed under this legislation, and so we think that there's a risk that some donors will say no. We'd rather not give you our money, we'll take our money elsewhere. And we think that's one thing to watch carefully. The Constitution is very clear around giving provinces and municipalities a very big responsibility for local socio-economic development in their province and their municipality. The bill speaks primarily about development at a national level and doesn't speak clearly around those objectives at a provincial and a local government level. And we think there's potentially a constitutional issue in that respect. Section 5, Section 6, we also think conflicts with some of the original legislative and executive powers of provincial legislatures and municipalities, and we've outlined those, Chapter 3 of the Constitution, the Intergovernmental Relations Framework Act, and also Section 5 of the MFMA. We think there might be some conflicts there. The district development model is not mentioned. There's no mention of districts in the bill, and we understand the some of the issues around MFMA and that respect. But it's speaking to the fact that there's insufficient focus on the local, the province in the bill, and the development at that level in the bill. The bill also in Section 1 defines the Act, and it defines the Act as being including regulations, code of conduct, instructions, and notices. Okay, so the definition of the Act is quite wide in what it includes. However, this Act has about 36 matters, and we've listed those, and you'll see them in the written submission, which is silent on. There's almost 70 terms in the bill that are not defined. And one of the issues of this is the bill still says, however, if an accounting officer fails to take reasonable steps to implement this act, they are liable for an offence which could include imprisonment. So we're almost setting the accounting officers and departments and to say, hey, you're going to get put in jail if you don't get ready for this act. But by the way, here's 36 matters we haven't covered yet, and we're actually not sure about these 70 terms. The organizational implications for provincial treasuries and institutions. The Act says, Section 4 of the Act says that a specialist office is required at the national level, the Provincial Procurement Office level, but it just assigns powers to the provincial treasury. Doesn't make any recognition that actually they may need the equivalent of a specialist office at a provincial level. It defines the functions of the procuring institutions, but doesn't make any provision for what the minimum organizational requirements of those will be, where it should be positioned. Right now, everybody knows that it's the SCM unit reports to the CFO. This is not clear on that. But one of the difficulties is the regulations, there's no empowering regulation to actually clarify that. And that may be a concern going forward. The preferential procurement, chapter 4, very pleased that there is a focus again on local content and production. That is something we need as a country. However, again, it doesn't allow for a focus at a provincial level. It doesn't allow for that focus it's just, we prefer South African goods and services that are locally produced, and doesn't give a preference. And we noted the point that was made earlier around the development aspect that you raised, that there is a provision there, but not for the local content and production. One of the difficulties with section 18.3 is there's some very powerful provisions in chapter 4, and we're pleased about those, the set-asides, pre-qualification, etc. But in one of the aspects, it says that if you are going to subcontract, you can only choose one of the following designated options. You could choose either to subcontract to a company in a province, or subcontract a company that is owned by Black people, or subcontract to a company which is owned by women. But you're not going to be able to say, we would like you to subcontract to a Black-owned company in the Western Cape. You have to choose one. And we think that might be a bit of a drawback on transformation as we progress. We are very followed and very appreciative of the difficulty that Treasury has had in trying to come up with the framework that they've put together. There's a mention in the bill about something called complementary goals. We think it's got some relationship to 90-10, 80-20 pricing, but it's not defined. And so it's material. It's such an important term in there, but we don't know what it is. And it's very difficult to say what this is. We all understand as a country, 90-10, 80-20, what that means and how that's going to work. But what is complementary goals? It's very, very difficult at this point then to say this is a framework. This might seem semantics, but it's so important. The bill says that we can have subcontracting as a condition of bid. But here in the Western Cape, we've got massive issues with the construction mafia. And if we go back to the history of where that construction mafia originated, it was in the 2011, 2017 regulations that started to talk about putting in subcontracting as a condition of bid. And that's not always practical. And we would rather suggest that we reframe that not as a condition of bid, but as a condition of contract. Semantics, but it's going to make the implementation of subcontracting a lot more practical. Let me explain briefly. If you say a condition of bid, then you're telling a supplier, you have to, let's pick up on the gentleman, you have to subcontract to this company in this small town. Okay, you have to subcontract to a company in that small town. But there might not be a company in that small town that is registered yet on the CSD database. And so you're forcing them to say with their bid, hey, this is what you're going to do from a contracting perspective. It might only be necessary when they land there in that town that they're going to start to consult with the people in the community there to say, we need a subcontractor from your area. But they've already said, hey, we're going to subcontract, and the company we're going to subcontract is here in the Cape Town, but then they they land in that rural town in the Western Cape and they say, we don't want these guys from Cape Town. We would rather have somebody from our town. And that is, we think, a fairly significant issue going forward. The dispute tribunal mechanism, I mean, good that we've got another mechanism that doesn't require you to go through the courts. But we think this has got a risk of paralyzing procurement in the country. Many people are saying there's a potential risk here. One of the issues is there's no maximum amount of time that bill can go through that process, and so it could be there forever. We don't know, right? The one other concern, and pleased to hear the discussion around panels, is if we look at one of the provinces in KZN, they've got a tribunal there. In fact, they've got two, one for local government, one for provincial government, and it is busy, it's hectic. And so there's a concern that with this one judge at a central level, it's going to potentially be a bit of a bottleneck, and we might, and we note the reference to panels, absolutely. There's also no provision in the bill for any transitional arrangements, and to put these tribunals together will take time. And it's going to be important that that transitional arrangement is clearly described. We also think that there is another mechanism called mediation, which is not factored into this bill, which is another way that you can more quickly resolve disputes before you get there, and it should at least be included as an option. Many have said at the NCOP level and elsewhere, just the bill says that there's no significant financial impact, and many are just saying we're concerned about that. The bill says we've got to increase capacity of organs of state. You can't do that without additional funding. What about the potential losses of donor funding? What about the hidden costs to provinces and municipalities and getting their organizations going in implementing the ICT? The setup cost, the operational cost of the tribunals. There's got to be a cost to these. What about the cost to that standstill provision that's there that might mean that contracts get cancelled? We've got to start again. We can't award it. We've got other things that we've got to do. The Public Procurement Office has enter and search powers. They're going to need capacity for that. And then there's also, and I'll come to that shortly, additional scope for the procurement officers in the institutions, which we think might also have an implication. There's a trumping provision, which we think needs to be carefully looked at, and we've identified some clauses in there that we think need to be just tested against that trumping provision. Section 1, 2, 3, 4, and 7, just again, the whole issue around cooperative governance is just not discussed. The bill is quite silent on that. We've identified 9 infringement areas in that in the consultation process of the regulations. There's no need for them to consult with COCTA or SOLGA. And then lastly, a couple of things that we're worried about. Provinces and municipalities, from an IT perspective, are not going to be able to have their own little databases. They're going to have to wait for the National Treasury one to come through. There's definitions at this level which are missing. One of those is methods, very, very significant, and pleased to see that it's there. We've seen that the example that's given is transversal contracts, and we're just saying maybe that's not a good example of a method. That might be a contract. It might be a sub-method of a method. Maybe just take that out. And then the bill says that the officers in these departments, procurement officers in these departments, will also have to look at contract management, asset management, and risk management. Now, they always have to consider that, but now is asset management the scope of procurement? So the municipal entity in the Western Cape has now also got to have the management of the water treatment plants, the assets, as part of their scope, and that we're concerned about that overlap. I mean, there's a lot of supply chain management thinking, which is in here, but we've gone from supply chain management to procurement, but we still have all the other supply chain management aspects to it. And then there's a provision that says we will have one platform for ICT in the country. And we think that that's going to be difficult to do, and we've made some recommendations for some appropriate provisions as far as that's concerned. Thank you, Chair.
Thank you very much for the very insightful comments on the bill. So we'll now move to our next presentation, which will be from Francis Chamelet. Mr. Chamelet is from the Group of Construction and Engineering Companies, a representative.
Thank you, Chair. And thank you to Treasury for making the time to come and talk to us and all the other members here. We are technical industry by nature, so we're definitely not legal by nature. So we've clearly got some advice from senior counsel and counsel in terms of our submissions. We have made submission to National Treasury on the 11th of September, 24th of November, and now recently 22nd of February. All of those submissions were made in haste. And we had very brief opportunities to submit or make oral representation. Those documents I have submitted to this forum. I've shared all three submissions, which I believe are quite substantive and give a strong legal submission as to where we are. I'm not going to try and run through all of them, which will take everybody's time. I think for the provincial proceedings, I think the first and foremost thing that comes to mind is the separation of powers. Well, let me just take one step back. I think we have the same aspirations and desires to achieve what Treasury is trying to achieve by the bill. And I think we're all supportive of that aspiration and desire, but we have to read the letter of the law of the bill, and we have to apply that irrespective of when regulations are going to happen, what future aspects might be, and we have to assess the bill as what the bill is, and then understand whether the implications of that bill are so. The implications of the bill are far-reaching, and we at the moment still do not fully understand it. It repeals or alters some 60 other pieces of legislation. To fully comprehend how the implication of all these things work, we don't know what the regulations are going to imply. So we sort of largely uninformed as to the implications of what this bill will do. And all we can really do is comment on what's written in transcripts right now. And the initial reading, and I'm just going to focus on four aspects to keep it short. The written documentation is before the House, and they can all read it. But the separation of powers under the existing proposed bill is problematic. And in Chapter 2, in Section 6.2, it says that a provincial treasury within its powers may issue binding provincial instructions on the procurement matters for effective implementation of the proposed act, and not inconsistent with the instruction issued by the public procurement officer, which effectively, in my plain English, says that the provincial treasury can issue instruction as long as the public procurement officer, as long as they're not doing anything different to what the public procurement officer can do. So effectively, the provincial treasury is hamstrung and are held responsible to procurement officer. In the same manner, the provincial treasury can apply that process to a municipality, for argument's sake. So in my reading of it, or in our reading of it, there's a separations of power process. I mean, if you look at a road, for argument's sake, and that's our industry is those type of fixed assets. A road is particularly, the legislation is written that a road is a sole domain of a province. So how does this affect the various parties, and is the separation of powers been adequately thought through? So that's one aspect. So it would appear that the public procurement officer has got the ability to veto the province and the municipality and overrule their decisions. And that's just from the reading of the bill as respect. So we take the Treasury's comments into mind. The other aspect is where we largely influenced is under Chapter 4. Now, under Chapter 4, there's the set-asides, which we understand, and historically there have been set-asides. The concern now under the set-asides at the moment, they are uncertain and they're unclear as to what these set-asides are set up for and what the limit of what they are. They could be worth billions. They could be, we don't know what, and there's concern that there's potential for manipulation or even corruption for that matter in terms of the set-asides. Then under the pre-qualification in the new Section 18, we have the same uncertainties, and there's no clarity in terms of how this legislation gels together with the role of the CIDB, for argument's sake, in terms of the Construction Industry Development Board, which has a mandate to oversee infrastructure development and to set up pre-qualification criteria, etc. Now, how do these two pieces of legislation gel with each other? And we believe that opens up potential manipulation or conflict. So in terms of that, then I'm going through this quite quickly, so I hope that's making sense. Then in terms of the Chapter 4 itself, I just want to go back to that file. In terms of Chapter 4 itself, Parliament, it is Parliament's job to create legislation that gives a framework, and that framework has got to be quite clear and specific as to how the process works. Chapter 4 does not do that, and it certainly does not meet the guidelines of Section 217 of the Constitution. What Chapter 4 does, it gives the general sort of set of terms, and then it allows or permits the minister to go issue regulations. And these regulations are not isolated to purely Chapter 4. It doesn't limit where those regulations. There can be any aspect in any chapter that the minister can change his regulations. Yes, he must consult on that, but a regulatory process is a lot simpler than a parliamentary process. And the whole intent of the Constitution is to say that Parliament, as a national overarching body, must do that work. The minister must apply the processes that Parliament have actually set in place, which would go to the gentleman from Stellenbosch's question. The Parliament should be giving those detailed, but pretty much be giving the framework with which in the minister work, and it shouldn't be set down to the powers. We're giving the minister a lot of power in this environment, which is a bit of a concern in terms of where we're looking at. Then the last aspect, which I just wanted to mention, is the intention and two aspects. In chapter 4, for some other reason, they've removed Section 10, which refers to the Broad-Based Economic Empowerment Act. And there's no explanation for this removal or omission as to the application of Section 10 in the Act. And there's a trumping effect between the existing mechanism and the old mechanism. In the old bill, the Empowerment Act, the Broad-Based Empowerment Act, trumped other legislation. This bill will trump the Empowerment Act. But this bill does not remove the Empowerment Act. It has the ability to allow the minister to turn the act on and off, in a sense. It is not at his discretion, but it does create an uncertainty in terms of the way the legislation is drafted. So our concern is that whilst there should be development in terms of broad-based black economic empowerment, which should be the drive and the focus of the country as a whole. But the fear is that this legislation, with its very broad, largely unclear guidance, could transform broad-based black economic empowerment into narrow-based economic empowerment. And there's a risk of that in terms of that manipulation in effect. I'll leave it at that. And in the rest of our documentation, we've submitted ours. Thank you very much.
Thank you very much, Mr. Shamale. We'll now move on to the next oral submission from Professor Gio Quino.
Thank you very much, Chair. So I'm Gio Quino. I am the Director of the African Procurement Law Unit, and we are based at Stellenbosch University. Very briefly, we're a multi-institutional academic unit focusing on the study of procurement law in an African context. And we've got affiliated researchers from more than 10 universities across the continent working with us. Chair, thank you very much for this opportunity to address the provincial legislature on this really important piece of legislation. In these submissions, we want to highlight 4 themes which we trust the committee and the provincial legislature will find of assistance in processing the bill and eventually formulating a mandate. As a point of departure, we welcome the tabling of the public procurement bill. We think that law reform in this area is long overdue and is of the utmost importance in pursuit of our national development plan, given that public procurement is really the engine room of government. There's not a single public service rendered in this country that's not dependent on public procurement. And that's something that I think should really be emphasized to understand the importance of the piece of legislation that we're talking about. Let me also say that while some of my comments, perhaps a lot of my comments, will be quite critical, we make them in the spirit of trying to avoid a piece of legislation being challenged after an arduous process of enactment to just be overturned again by the Constitutional Court or subordinate legislation under such act, and the chaos that that will bring again to our procurement regime, as we've seen in the past to be the case. We think we must all work together to try and craft a piece of legislation that is as review-proof as we possibly can get it. And we offer our comments in that spirit. The four themes, that we want to focus on are: 1, legal consolidation in public procurement; 2, constitutional questions; 3, preferential procurement; and 4, resources. And I should also add that we will be submitting detailed written comments as well. So firstly, consolidation of public procurement law, and I think both presenters have already spoken about this. We welcome the bill as a long overdue step towards consolidating our law on public procurement. As National Treasury, I think, has very accurately noted, it's no secret that one of the biggest stumbling blocks in public procurement in South Africa has been the extreme fragmentation of the law governing this area. The law simply spread out over too many different instruments, which undermines efficiency because it is simply too difficult for procurers and suppliers to have a firm grip on the law. And it enables corruption to thrive in a complex web of rules and technicalities where there's lots of space to hide. However, the bill, while it's positive, risks future fragmentation through excessive reliance on regulations. And we propose limiting this by 1, setting clear principles in the bill itself. So key elements like procurement methods should be defined within the bill itself, not left to regulations. Precise delegation, secondly. Any delegated powers for regulation should be accompanied by very clear parameters and guidance in the bill itself. 3, focused regulations. Regulation should only deal with specific details of implementation and not with core principles. The current approach of the bill, leaving vast areas to regulations, raises serious concerns about transparency and accountability. I should also point out, Chair, that this approach is completely at odds with the international consensus on public procurement law. Across the globe, from mature, developed procurement systems to recently established developing countries, the clear norm is that the primary statute, that's the Act, contains a complete framework for all aspects of procurement, and that the regulations only provide further detail. In the statute, one would thus find the key principles, for example, of procurement methods, of qualification, of adjudication criteria, of cancellation of procurement, how award decisions should be taken, minimum requirements for solicitation documents and advertising, pre-qualification mechanisms, etc., etc., etc. The regulations will consequently flesh out the framework, but will not contain any aspect of the procurement system for which the framework is not already provided for in the primary statute. And this is also evident in the leading international legal instrument on public procurement globally, which is the United Nations Commission on International Trade Law, UNCITRAL's Model Law on Public Procurement, which has had a major influence on our continent, including most of our neighboring countries that's also adopted procurement laws in the recent past. And Chair, I should just note that South Africa has been a member of UNCITRAL when this model law was adopted, and we continue to be a member of UNCITRAL. On preferential procurement, and I'll come back to this topic in a bit, too many key concepts are left open-ended for the minister to determine, as my colleague has also just noted. For example, thresholds on conditions, sections 17 and 18. Prescribed criteria, sections 17, 18, 19, and 20. Complementary goals, 17, 18, 19, 20. Preferences as prescribed, section 21. prescribed conditions for measures to advance sustainable development, section 22. All of these are not defined and they're simply left to the minister to give content to. The new powers granted to provincial treasuries to issue binding instructions to local government poses another threat of new forms of fragmentation. Not only will this subject municipalities to multiple sources of instructions, national and provincial, but it also opens the door to different approaches to procurement in different provinces, based on different provincial instructions. We should also note that the caveat here that provincial instructions will be subject to Public Procurement Office, that is national instruction, raises some very serious constitutional questions. Because ostensibly, this act proposes that all national instruction will always automatically trump provincial instruction. Chair, that is simply at odds with the very, very careful provisions of our Constitution about tension in relation to national and provincial legislation. We should not forget here that these instructions, according to the bill, carries the power of law. They're defined to be part of the Act. It means they subordinate law. One wonders how a statute can simply enact a blanket trumping in the light of sections 146 to 150 of the Constitution, which attempts to craft a very careful balance between national and provincial. This is highly problematic. In our view, some more work will have to be done on the bill in this regard, if it is to succeed in one of its primary aims, which is to avoid fragmentation and to bring consolidation, which we think is very important. Secondly, there are various important constitutional questions, and I highlight only a few of those of particular relevance from a provincial and local government perspective. The first constitutional concern is the need to anchor the bill and hence a future procurement law squarely in section 217 of the Constitution, which is explicitly the section that grounds all procurement law, as our Constitutional Court has repeatedly confirmed. The proposed bill fails, in our view, to address how to implement the 5 vital public procurement principles enshrined in section 217 of the Constitution. And this silence leaves officials vulnerable to legal challenge, and it hinders the practical application of maximum value for money championed by the Zondo Commission and the President, for that matter. Specifically, the bill offers no guidance on navigating trade-offs between, for example, principles like fairness and cost-effectiveness, or equity and competitiveness. These principles are inevitably in tension, and a balance must be struck in every particular case. The bill provides us with nothing on how that balance is to be struck. This lack of clarity weakens the legal ground for designing policies, methods, criteria, but also regulations by the minister himself. And it opens the door to legal challenge. Experts, including the Zondo Commission, have highlighted the lack of clear implementation as a major stumbling block in the current system. Therefore, the bill should provide a framework for balancing these principles throughout the procurement process. This includes defining how value is determined and the parameters for considering factors like price. In our view, kicking the can down the road by simply saying further criteria is not addressing this key concern. Without such guidance, achieving optimal value for money and ensuring a functional procurement system remain major concerns. The second constitutional concern that also links to some of the comments already made relates to cooperative governance. And Chair, I think this is probably the most significant issue for this committee and for provincial legislatures to deliberate on. The bill's centralizing tendencies regarding procurement raise significant concerns about its compatibility with the Constitution's principle of cooperative governance. This centralization manifests in several ways throughout the bill. Firstly, through extensive regulation. The bill heavily relies on regulations, instructions, notices, leaving limited control for individual organs of state over their procurement policies. This significantly reduces the autonomy of local governments, especially who currently have legal authority to set their own policies. Chair, I think in this regard, we need to be especially careful with terms such as centrally led and claims that we have at the moment a centrally led procurement system. That is simply not an accurate way of depicting our current procurement law system. Centrally led under the PFMA means one thing. Under the MFMA, a completely different thing. Under the PFMA, centrally led means that National Treasury's got the power administratively to prescribe to national and provincial entities how they should go about procuring by way of instruction. Centrally led in the local government space at the moment under the MFMA means nothing more than central legislation prescribing to local governments how they should procure. The real power in terms of policy and implementation at the moment sits with local councils, elected officials at local government level. That power disappears under the current, under the bill. And that's a major shift towards centralization. The power over key aspects like procurement methods and preferential practices shift heavily towards the national level, potentially violating the constitutional mandates of local and provincial governments in constitutional sections such as 151 to 153, but also 104 and 125. Sean has already noted a concern around the lack of consultation with organized local government structures in creating these instructions and notices. And then finally, a concern around a national dispute resolution mechanism. While we also welcome an administrative structure to deal with disputes, and we agree that this is the correct direction to move, we are concerned that the proposed single national tribunal for procurement disputes raises concerns about potential bottlenecks and delays. In our view, a decentralized structure with provincial or regional tribunals would better align with cooperative governance principles. We note the remarks around panels, but Chair, as my learned friend right next to me noted, we've only got the text of the bill to work with. When we look at the text of the bill, there's not a word about the fact that these panels will operate regionally. The bill as it currently reads tells us that for every single challenge, every single dispute, a panel will be constituted by the chair. That is at a national level. There's no guarantee in this bill that it will be implemented in a way that will result in a decentralized system. That's something that I think we need to address in the bill itself to achieve that objective. These issues pose practical and constitutional challenges. The diverse nature of South Africa's public procurement landscape necessitates a more nuanced approach that balances national oversight with local autonomy. Centralizing power at the national level disregards local knowledge, local needs, and geographical disparities, potentially hindering optimal procurement outcomes. Furthermore, the lack of consultation with local government contradicts the spirit of cooperative governance and could lead to legal challenges. A more inclusive approach, respecting the distinct mandates of each sphere of government, is crucial for an effective and constitutional procurement system. Therefore, Chair, we recommend a thorough review of the text of the bill and the power allocated between the spheres of government. A more balanced approach, granting local and provincial governments greater autonomy while ensuring national oversight and compliance, would better align with the Constitution and enhance the effectiveness of the public procurement system. Thirdly, preferential procurement. Chair, I deliberately do not want to focus too much on this topic, not because I don't think it's important. It is of critical importance, but this is a topic that's received a lot of attention during the process and often to the detriment of other important aspects. Let me just say the following. A major concern with Chapter 4 of the bill that sets out a new preferential regime is that it arguably exceeds the scope for national prescripts in this regard under the Constitution. Section 2172 of the Constitution states that subsection 1 of section 217 does not, quote, prevent the organs of state or institutions referred to in subsection 1 from implementing a procurement policy that provides for preference, etc., etc. Subsection 3 then states that such implementation must occur within the framework set out in national legislation. The problem with the bill, and chapter 4 in particular, is that it goes considerably beyond creating a framework within which organs of state must implement their preferential procurement policies. The question here, of course, is what is a framework? When do we know we've got a framework? And without trying to provide any comprehensive definition of what a framework is, I think one can easily agree that a framework can never be the whole. A framework is only a structure within which content must be given. So when we are looking at something that's the whole, it is by definition not a framework. And I feel that's what we've got in this chapter. If one looks at chapter 4, especially read with the further regulations to be issued under chapter 4, it seems to me that this is not a framework. It is, in fact, a very detailed and prescriptive set of rules that organs of state will seemingly be bound to. Chapter 4 prescribes the exact mechanisms that may or may not be used, such as set-aside, so-called pre-qualification, subcontracting, etc., leaving no discretion to organs of state. And it prescribes the substantive content of these mechanisms, in terms of which groups may be targeted by these mechanisms and within what thresholds. It is difficult to me to imagine what further content organs of state must add to these provisions to arrive at their full preferential procurement policies to flesh out the ostensible framework for which the Constitution provides. This implies that what we see in Chapter 4 is not a framework, as required by Section 2173 of the Constitution, but indeed a complete, full preferential procurement regime. In this way, the bill exceeds its constitutional mandate and, coming back to my earlier point, is not aligned with the constitutional principle of cooperative government. There are also other problems with Chapter 4 that I won't go into here, such as, for example, the highly convoluted structure with multiple mechanisms operating at somewhat opaque relationships with each other, very narrow approach to preferences, as Sean has already pointed out, that may indeed result in narrowing of preferences, preferential procurement, undefined concepts, and a general sense of vagueness, which leaves much room for legal contestation. And again, our fear here is that the bill itself, or more likely the regulations made under the bill, will be constitutionally challenged, and that such a challenge may succeed and really set us back in our attempts to use procurement to further constitutional transformation. Chair, finally, a few remarks on resources. The bill introduces significant new functions and shifts existing ones, demanding substantial resources for successful implementation. However, the bill fails to adequately address capacity needs or professionalization, raising concerns about its feasibility. The bill imposes several additional tasks on provincial governments, especially treasuries, and also on local governments. These include things like enforcement functions, investigations, internal review structures, market research obligations, etc., etc. However, it offers no statutory basis that guarantees the enhancement of their capacity to fulfill these roles. The roles. The socioeconomic impact assessment report that accompanied the bill acknowledges implementation costs for provinces and municipalities, citing needs for additional staff, additional technology, additional training. However, curiously, the bill's accompanying memorandum, submitted when it was tabled, contradicts this, claiming no substantial financial burden on the state. This discrepancy raises serious concerns about the accuracy of costing and the commitment to resource allocation. Chair, we propose adding a provision to the bill that explicitly mandates increased capacity and professionalization to the procurement function. This provision should oblige relevant departments, like national and provincial treasuries, to allocate additional resources to procurement functions commensurate with the expanded mandate. Not doing so will simply add to the current burdens of unfunded mandates. Additionally, incorporating requirements for mandatory competency levels and training obligations would foster professionalism and efficiency within the system. Ignoring these resource concerns risks creating an unenforceable and underperforming procurement system. And by ensuring adequate resources and professionalization, we can pave the way for the bill's successful implementation and the achievement of its stated goals. Chair, thank you very much.
Thank you very, very much. All right, so with that, we'll move on to the next submission, online submission. There's been a request from Sapura. Sapura, if you'd like to unmute yourself and deliver your oral submission.
Thank you very much for the opportunity to participate in this hearing. My name is Sapura Sadek. I'm a resident of the Western Cape, living in the southern suburbs. So before I go into my actual submission, I've listened quite carefully to the previous 4 inputs, and I think my submission speaks to what I have picked up as a common thread between the 4 submissions that have been made. But I also want to say that I am quite happy to be the first female speaker outside of the legislature, and certainly the first person of color to be speaking on this very important bill. I speak as a resident in terms of how legislation broadly impacts on our lives as residents, and not necessarily from the position of academic studies or arguments. I'm not a legal person, so I think that must be borne in mind. The one thread I pick up in the 4 presentations that have been made, I think there's been some very useful contributions that can enhance the bill and fill some of the gaps that do exist. And listening to the contributions themselves, I think that those that are useful to enhancing the bill are contributions that can quite easily be addressed by the legal team of the, and certainly the team based on the presentation that they have made, and should be done in a manner that does not delay further processing of the bill. The one issue I do pick up, and which is of great concern for me as a resident of the Western Cape, is the common thread and message by the 4 previous speakers, which are raising issues around a unitary versus a federal state. And I think that I have picked that up between the lines of the contribution. I've noticed that words like autonomy between national government and municipalities, etc. I've heard, I think each of the speakers speak to the issue of cooperative governance in Chapter 3. And it's an area of the Constitution as a resident of the Western Cape that I have looked at particularly closely in the context of the Western Cape provincial government, through a bill seeking more provincial powers from national government. So I, as a resident, what I'm reading between the lines, and the speakers will forgive me if I'm incorrect, I'm not expecting, and in fact, I don't necessarily want an answer to that question, but I have noticed, and I would like this hearing to note, that there is an underlying tone and that provincial powers have been raised several times, and provincial autonomy. So in my submission, I would like the bill to ensure, and as I said, I'm not a legal person, but I would really like the bill to address issues in the Western Cape province, and I'm not sure to what extent they exist in other provinces. Issues where the lack of national oversight, national structures, and national guidelines around procurement has led to particular instances, and I will give examples. So I want to say that I definitely support before I go into my example, I most definitely support the public procurement bill. I have read parts of the bill, not from a legal perspective, but from the perspective in terms of the kind of consultation processes leading to the bill, the research done, etc. I think this bill is critical, and if anything needs to be passed as an act of parliament, as a matter of priority, because for me, the bill is representing one of the most tangible actions from national government to deal with a process which the last speaker spoke to quite extensively. And that is the issue of how the procurement processes have led to corruption. Okay, so for me, I think it needs to be recognized as a tangible action, and a tangible action that needs to be put in place as soon as possible, because procurement processes have been used not only for corruption, but procurement processes have been used around irregular expenditure, around wasteful expenditure, etc. The Chapter 3 of the Constitution on Intergovernmental Relations actually is quite explicit and provides a very structured way for the three spheres of government to ensure that the alignment between the processes, systems, and structures around public procurement do find are aligned to each other. And I think that I've certainly found in a Western Cape situation that Chapter 3 and the opportunities that Chapter 3 of the Constitution gives for ensuring that that alignment has not been used to its full capacity, and in fact has been used as an argument to vote against. I mean, I find it interesting that yeah, we talk about centralization, but what we're talking about is a unitary state with three spheres of government, and those spheres and their roles and functions, concurrent and exclusive, are very well explained. So I think that, to my understanding, the bill has taken into account, and if it hasn't done so sufficiently, then it perhaps needs to look at it. So from a Western Cape, I'm going to use the Western Cape Department of Education as an example, okay, of why I believe that there needs to be stronger, in inverted commas, centralization, guidelines, structures, oversight around public procurement processes. So I looked at 4 annual reports of the Western Cape Department of Education. Its acronym is known as WCED. And I looked at just this for this term of governance from the period 2019 to 2023. And I looked at the reasons provided for irregular expenditure. And I'm now going to quote, as part of my submission, directly from the 4 annual reports and the reasons that were given for irregular expenditure. Okay, so in its 1920 annual report, page 15, there was irregular expenditure to the value of 3.275 million. Okay. And the reason provided in the annual report is this is mainly resulting from incidences of non-compliance with Treasury regulations on procurement of goods and services. The same department's annual report for 2021 financial year on page 18 reports irregular expenditure to the value of 5.841 million rands, mainly resulting from incidences of non-compliance with Treasury regulations on procurement of goods and services. Its annual report for the 21-22 financial year, page 14, irregular expenditure of 62.49 million rand was reported. Okay. The reason again given, and you can go and look it up, that's why I'm giving you the page numbers of the reports, mainly resulting from incidences of non-compliance with Treasury regulations of goods and services. The last annual report, 22-23, irregular expenditure to the value of 57.124 million. The reason provided, mainly resulting from incidences of non-compliance with Treasury regulations on procurement and goods of services. I did look at one report, and strangely enough, on the Western Government website, I couldn't find more than one annual report to look at in terms of the Department of the Premier. And that was its 2021 report on page 19. It reveals that there was irregular expenditure. It doesn't give the amount of the total amount. It talks about 4 cases of irregular expenditure by the Department of the Premier. And of the 4 cases, it says that 2 cases amounting to 398,700.23 are still under investigation. 1 case amounting to 136,982.58 was condoned by Provincial Treasury, and that 1 case amounting to 1,632.82 was condoned by Provincial Treasury. This annual report does not provide any reasons regarding this. It doesn't say when the investigation was started, when it's likely to be concluded, what are the cases involved, why was irregular expenditure condoned by the Provincial Treasury, on what basis, what guided Provincial Treasury, what rules and regulations did they abide by and use to condone this. Okay, so none of those reasons have been provided. A previous speaker, one of the previous speakers, I can't remember if it was the first or third speaker, but spoke about how this procurement bill, supposedly because it does not acknowledge the autonomy of provinces and local government. And I want to remind us that according to the Constitution, there's no autonomy between the 3 spheres of government, but they are concurrent and exclusive powers. But he talked about how the centralization is preventing, for example, the Western Cape. And he used the example of Western Cape Province in particular, where he said that it will prevent the Western Cape from being able to procure the services of a Black-owned or disadvantaged grouping or marginalized sector, that business, okay, to be able to procure service or to become service providers of the Western Cape. And I find that comment very, very interesting. And I wonder if the whoever that speaker is aware that with the current system of procurement and the lack of clarity and the examples I've given already, where there is disregard, I've given you the words, hey? Incidences of non-compliance with Treasury regulations on procurements of goods and services. I would love to understand that how it is that the city of Cape Town recently, and this has been reported in newspapers, recently has just signed a contract worth 2.8 to 2.7 million with a company based in Johannesburg, registered as a real estate company, to provide the city of Cape Town with its executive transport services. So a real estate company based in Cape Town has got a contract for a period of 4 years amounting to that for executive transport, and that the company is owned by a person in the United States of America. Is this what we want to continue to allow to happen? Is this why we choosing to find what I believe are minor faults with a bill that is, as I started off saying, is a real tangible example and a tangible action taken by national government to begin to deal with issues of corruption across all 3 spheres of government. And so I want to end my oral submission with saying, while I recognize and I respect the amount of work and research that has been put into the presentation of the previous 4 speakers, I do want to request that the parliamentarians in this hearing, and particularly the policy and legislation people from National Treasury, are aware of and take note of my concern of the underline or the writing between the words that speaks to and proposes that this bill must be a bill that should be drafted in a manner that will allow for more provincial and local government autonomy. I do think that Chapter 3 of the Constitution is important, and I would believe and understand, and certainly from the part of the presentation that I did hear, I'm sorry I had joined a bit late. I think that there has been sufficient consideration, and so I support the bill, and I think that whatever weaknesses, tangible, realistic weaknesses, and not underlying messages that are arguing for more autonomy and more devolution, in inverted commas, of national powers to provinces and local municipalities, using an argument of broad-based Black economic empowerment within a province or within a municipality, when there is a glaring example, like the one I gave of the city of Cape Town, having procured services, executive transport services from a real estate agency by a company owned by the United States of America. I believe that this bill is intended to address and make sure that such things do not happen in future. Thank you very much for the opportunity. I don't know how many speakers you have left. I do hope that there are women amongst them, and I do hope that there are a fair representation of people of color, being Indian, African, and colored, making input into this bill as well. Thank you.
Thank you very much for the submission. I'd just like to check quickly before we go back to Mr. Scott. Mr. Scott, if you'll indulge me, I understand that some people do have their transport arriving now, but we don't want you to miss out on your opportunity to make an oral submission. So if you could just raise your hand if you do have transport coming and you'd like to make an oral submission before you leave. Is there anyone? Okay, I see none. So with that, we'll go back to Mr. Scott to speak on the National Research Foundation submission.
Thanks very much, Chair. This I was called this morning.
Apologies. I also just wanted to allow and excuse those who do have transport that have arrived to make your way through, and of course help yourself along the way to the refreshments that we've laid out, just so you don't miss your ride. Thanks.
Thanks, Chair. I was called this morning by the National Research Foundation who asked me just to make an oral submission on their behalf, and you have got evidence of their request supporting this. Just the National Research Foundation is part of the National Science System. The Western Cape in particular has got a long history of innovation, and the observatory is recently celebrated its 200th year birthday. The Itemba Labs is a Western Cape facility based in the Western Cape that is one of the few in the world that develops radioisotopes in the use of cancer treatment. These are part of a national entity, but they work very closely with departments and other entities in the Western Cape. And they wanted to just get some points across. One is, although it's a national entity, their mandate does extend to all institutions, including provincial departments and municipalities as well. They're appreciative of the opportunity to provide comments. They note that the innovation has been included in the Public Procurement Bill through previous submissions, but they're concerned that there is potentially an inhibiting factor to innovation going forward. And they're concerned with that, and believe that it should not just be a subcategory within Section 22G, but elevated to the same level as some others, such as to promote innovation. One of the problems at the moment is that the bill primarily removes discretion of procuring institutions in many aspects, has been raised previously, and they think that there needs to be specific procurement methods to address the procurement of innovation in the bill. Procuring innovation is something which requires different methods to conventional procurement. You could think of the extreme that you're buying something that hasn't been invented yet. How do you do that? How do you buy something which is still to be developed? And that is part of the difficulties in the innovation space. And it requires a different focus, different culture, different incentives, different understanding of risk. The National Research Foundation has identified almost 200 methods, of which about 40 of those are for the procurement innovation. And it doesn't seem like, as far as the National Research Foundation is concerned, there's sufficient recognition of the capacity and the competence requirements that are needed for this. Their recommendation is that specific methods for procurement of innovation is included and clearly defined in the system of methods and procedures. They also raise the issue around the trumping provision, which has been raised previously, and they've got a specific reference there to how it impacts around innovation, and particularly the act that has established the National Research Foundation. They've also raised a whole range of issues around the cost implications of that, which have been defined previously, and believe that it needs to be quantified and needs to be acknowledged that there are cost implications of this bill. They've picked up on the centre-led, but that it's not an independent body and it's not appropriately capacitated. The Public Procurement Office is still to be located in National Treasury. A significant regulatory effort is going to be needed. But if you look at Treasury, they have a fairly limited track record in regulation. The Preferential Procurement Policy Framework Act has been around for 20 years unchanged. The regulations have only been changed 4 times. The PFMA, Provincial Treasury regulations, have not changed since they were first issued in 2005. And yet we're looking at an existing capability to try and now significant regulatory requirements. And do they recognize the difficulty, and do they have they capacitated for that? It's not going to be a standalone regulator, as many other organizations, functions also do have. It has no oversight office, no oversight capacity. It is within the Treasury. That office has enter and search powers, but that office is also going to be procuring. Who's going to enter and search the Public Procurement Office? And so they're recommending that this either be established as an independent regulator or with an oversight body that would involve the provinces to also have oversight of that, and recommending that it significantly increases its capacity for the regulatory development and management of these new regulations. Thank you, Chair.
Thank you very much. We do still have an opportunity for any final oral submissions, and I recognize the gentleman at the back up there. Sir?
Thank you, Chair. My submission is just a re-echoing.
If you could just state your name and your organization again, please, for the record.
Yes, my name is Rudzani Kennedy Ramatea, and I represent civil society of South Africa from Stellenbosch. Thank you. My contribution or let me call it, I will just only re-echo what has been said, but in a different manner. The second speaker did make a submission on subcontracting, which I believe and I really support very much. That is something that we have to look at. As much as subcontracting is very important, and to speak frankly about this manner, I believe that we have to look at not only employment diversity, but patriotism. This is still South Africa, I believe. And as it is still South Africa, I believe that we have to look at those subcontractors and who they are employing. Something that is really unseen, something that is not being talked about a lot, but I do see a lot of foreign nationals which are taken by the subcontractors. And there is a popular term that says that South Africans are lazy. I believe that South Africans do not have information. And that's something that I believe that these companies that are given such tenders rightfully, because they applied and they did all the due diligence and everything was correct, and that are mandated to subcontractors, so have to also do due diligence on who the subcontractors is employing. And I believe that that is something that will create a lot of diversity in terms of knowledge sharing and exposure, especially for locals. That should be something that is mandatory. And I speak like this because I myself, I'm from a family where my mother was working for a municipality for 10 years. And my father was a land surveyor for Eskom, running the power lines, especially in Limpopo area. And I saw a lot of plans at home and a lot of this kind of information going by. I once saw a check for 200 million rand pass just through my eyes, my mother signing it. And I wondered, 200 million rand signed like that, what is the process? And she explained to me. But I saw a lot of things. I was still young, but now I believe that although I do not have gray hairs, I have a fair understanding. And with that being said, there's a lot of things that are being missed. Yes, companies are winning the tenders, they are winning the bids, but they are not doing that due diligence, which will support knowledge sharing for communities and empower South Africans, I believe. And yes, for me, I am one person who is in the field of technology and ITC. And one thing that I can say with regard to that is because is that I specialize in reduced risk. So I reduce the risk of doing business. I speak to international organizations, companies, investment groups, and I help them in a way to find systematic ways to invest into Africa, especially mining communities or so, and how to reduce their risk of strikes and many other problems by doing social good. And for me, speaking on this, I speak on the case of risk because we run a huge risk right now of having a big, not a balance of scrutiny, if I might speak. Yes, the processes are open-ended, and they're open-ended until the minister might say something else. And I do understand, and this were comments that were made by the fourth speaker. I believe that it gives us, it brings us to a place where we have an open-ended process where the minister can therefore say, and it happens at the end, but also looking at the bottom area or so, it is very open-ended where it is not really seen and scrutinized about who is it that is being employed. And I believe the fifth speaker did speak about the case about an American company looking into having catering services in South Africa, in Cape Town, while they're based in Joburg. I believe that that chain is a very long chain, but the money all leads to the US of A. Now, on the matter of scrutiny, I'd like to suggest maybe, yes, and I do support the second speaker again on us looking at technological ways of looking at the procurement system. And I do support that we look at creating more like systems or so. I also do a lot of systems thinking, hence I do reduce risk. And with this, one thing that we have created on our side, if I might speak just briefly on that, maybe just as a key suggestion and to give leeway or just to raise other thoughts or so. What we created a system called We Earth. Before we do anything in communities, because we have to reduce the risk of doing business for other international companies, we ask the community, what is the need of your community? And then they choose and they tell us, and we see what the need is from our system. So it gives them different options. And from that, what we do, we say, okay, which projects can we create that will make sure that we can get along with the people, because we have to understand the culture of the community. We have to understand the people themselves. And then with most of the projects that we have to do, we also have to give tenders in a way. Our tender process looks like this. It says that for local companies that are there in the area, we want to use you. We want to work with you. But for you to work with us, we have to see your social, how you're giving back to society. So before we even go to many other things, we want to see how you're giving back, not monetary ways, but also skills. How many local people are you employing? Because that is very important. And now from there, how we go on further into the process is that we actually say we want to see you give back to community. So on our platform, you can create a cause where you take people in the community and you say you are a subcontractor or a contractor in this project or so, and these are how many people in the community, so that at each and every single time we can have number of people that we say, okay, these people are from the community, and we have made research and we are sure that they are from that community. So it's a different way of looking at things, but yet it still goes to the very same point. I believe that one thing that we need educated South Africans, because an educated South Africans is one that is not lazy and will not go to bribery, because bribery is a result of being lazy. We need to educate our people, and dissemination of information is something that is so critical and so crucial. If these companies that are operating in our areas are not doing anything much, but just saying, okay, we're just going to employ and do this project without giving an understanding, without sharing the understanding why this is important for a certain area, I believe that will go to more and more problems of corruption and more infrastructural damage, which will remove a lot of investment from South Africa. I live in a place where in Stellenbosch, it would seem as if it is where the rich stay. And of course, it is where the rich stay. It is a tale of two cities, and that is a book, but yet I live it in reality. I live in a Stellenbosch where there is a problem with some oak trees. A person makes a comment on the WhatsApp group, and the community leader or the councillor says, this has to be taken into account. Why? Because without trees, it's a 10-degree difference of temperature. 10 degrees difference of temperature means that we can lose billions. Why? Because it directly impacts productivity. I specialize in technology, and I understand what a rise in temperature in a specific area where there's a lot of business, what it means and how it affects the area. And now engineers are deployed. But on the other side of the city, I say in the first city, on the other side of the city, there are potholes, there is a lot of crime, there's a lot of this and this and this and that. But what happens? Tenders have been given, but to whom? Who have they employed? There has not been any, let me just say, dissemination of information to the local public, so much that there's a lot of infrastructural damage and a lot of things that are never addressed. So I believe that we need more family meetings like this, that we need to speak and share ideas. And especially a lot of young people are here to help. I'm willing to help and have these conversations and share my kind of technology that we build at my company so that we can make sure that we can contribute. I want to contribute to a fair South Africa, to a just South Africa that has empowered people. And especially within the Western Cape context, I'm also looking at the indigenous people, colored people, and the Khoisan people predominantly. I believe that they should be given knowledge that will empower them and make them understand that this is their land more than anything. Thank you.
Thank you very much for the submission. I'd like to check, are there any further oral submissions? Any further? Last opportunity. Ma'am?
My name is Maria King. I'm from Stellenbosch. I hear the gentleman now, but I will talk Afrikaans. We have a big problem in Stellenbosch. You know, around Cruiseville, around Idasvallei, they always pop up like mentions. We didn't know who give the land away, but the land is going. Our people didn't have land. We live in backyards. We have a problem there because the municipality don't want to talk to us. They don't want to talk to us, and I know that land belongs to us. It's us heritage land. So what must we do in Stellenbosch to get that right? Because we don't have land for children, for our children must live by us, because the mentions go up for the rich people from America, from Germany, from that, not from Stellenbosch, not from South Africa. So what must we do? We have a big problem in Stellenbosch. I don't know. We listen now about this bill, but I was going one time to a contractor. He was busy in Cruiseville. I asked him how many colored people you have in, because it's a colored place. He said no, he can't take the people, he bring his own people. I said, no, you can't work here. So that is the problem that we sit with in Stellenbosch. And we can talk to that mayor, he don't listen to us because she thinks she's most an advocate and she's better than us. So we have a problem, and I don't know that our children or grandchildren will have a place. You know what they do in Cruiseville? They told us that that land they use now for the white people. I'm not racist, no? For the white people who come from other places, not from Stellenbosch or the Cape Town, they give it to them. What about our children? They said that is our land. They built around us. We are in a cocoon. We are like a small villages. We can't go out. They built us. They take us from town. We was living in town, in Stellenbosch town, where the university is, where The municipalities, there was all our people living. They asked us to go to Clutisville, Idris Valley. They will provide land for us further to Klapmuts. What they do? They build us too. What must we do now? We have a big problem in Stellenbosch, and we talk about this a long time with the municipality. They don't listen. We hear now. I listen to this. Our people can't work. There's no work for our people in Stellenbosch because the contractors come with their own people there. So that is the big problem we have in Stellenbosch. And I want to know, you are the city of Cape Town. Are you part of Stellenbosch? Because we didn't know if you come in Stellenbosch. If you part, you must come and do something right there or do it something there. Because there's a construction mafia looking. Because when we get up in the morning, we see there's places getting up, there's places getting up. We don't know. It wasn't talked to us about. Wasn't and the IDP. When we come there, they already decide what to do. So we in Stellenbosch have a big problem. I hear that guy there, and it is a problem. Our place in Clutisville, in Idris Valley, is the potholes. The states are not, but in the town, oh gosh, that is where only the students must walk nicely, and rich people. That's our land, but we can't take it. Somebody else can take it out of our side. So that is our big problem in Stellenbosch. Thank you very much.
Thank you very much, ma'am, for your submission. I think that brings our submissions now to a close. I would like to thank everyone who provided a submission this evening. Again, I know that you've really gone out of your way to be here, and so we really do appreciate the feedback that you've given us and that we can then incorporate into our feedback to the National Council of Provinces. So with that, I wish you all a very, very good evening going forward. If you like, please help yourself to the refreshments that we've left at the back over there. And we really appreciate everything again that you've provided. Have a good evening, everyone. Meeting adjourned.